In this lecture, we shall discuss the execution of judgments for the recovery of money by charging others and by the appointment of a receiver. Execution of judgments for the recovery of money by charging others and the appointment of a receiver. Now, the starting point for our discussion is Order 43 of the High Court Civil Procedure Rules 2004 CI 47. Order 43 is headed Enforcement of Judgments and Orders. And it reads as follows, and I quote: subject to these rules, a judgment or order for the payment of money, not being a judgment or order for the payment of money into court, may be enforced by one or more of the following means. A. Writ of feri facias. B. Garnishee proceedings. C. A charging order. D. The appointment of a receiver. And E. In a case in which Rule 5 applies, an order of committal or a writ of sequestration. So you will notice that Order 43 Rule 1 mentions a number of ways in which a judgment or order for the payment of money can be enforced. In our previous lecture, we have discussed writs of feri facias and garnishee proceedings. The focus of this lecture is to discuss executing a judgment for the recovery of money by a charging order and by the appointment of a receiver. What then is a charging order, which is the first one we shall discuss? To explain charging orders, I shall make reference to a leading book in civil procedure in Ghana titled Civil Procedure, A Practical Approach, authored by the learned Kwame Tete. And I'll be reading from page 1036. This is what the learned author says at page 1036, and I quote: for some reason, it may not be convenient to levy execution against a property standing in the name of the judgment debtor, or property in which the judgment debtor has interests. For example, the judgment debtor may only own the reversion, which may not fetch a good price, or the judgment debtor has concluded a business deal involving property that would not permit a sale of the property. In any of those situations, the execution creditor would obtain an order charging the property with the judgment debts. A charging order is an indirect enforcement of the judgment or order by the creation of security over the property charged and making the execution creditor a secured creditor who must enforce the security in order to realize the proceeds of the judgment or order. The charge affects only the beneficial interest of the execution debtor in the property and no more. The execution creditor gets no more than what the execution creditor could have given. What is the learned author saying? Remember, we are discussing charging orders within the context of the modes of enforcing judgments for the recovery of money. We are being told that there may be a time that you can have a judgment for the recovery of money, But it may be inconvenient to levy a execution against the property that is standing in the name of the judgment debtor, or the judgment debtor has an interest in. So there's a property. So rather than you selling the property, you can apply to the courts and rather create a charge over the property. So that when you create a charge over the property, then you can take steps so it will make it look like now you have a secure charge over the property. And so you can realize that charge and then get the property, the money later from the sale of the property. So, in essence, it's not convenient to levy execution in the name of the judgment debtor right now. But you can go to the court and get some security over the property, some charge over the property. Once that charge is created, it cannot be sold because you have a charge over the property. It cannot be sold without recourse to you. More like you even have a mortgage over it. So if you have a charge or some form of security over the property, then it means that you are secured. It will be treated as though you are a secured creditor to the judgment debtor, and the property is what he used to secure the amount of money you give to him. That is why the letter order says at page 1036 that a charging order is an indirect enforcement of the judgment or order by the creation of security over the property charged. And then you, the one who has won the judgment, you will be made the execution creditor, and then you'll be a secure creditor. So if you are a secure creditor, it means that if I gave you 1 million cedis, it is treated as though your property is what you use as the loan, as the security for the loan I gave to you. That's why the Leonard order says that a charging order is an indirect enforcement of the judgment or order by the creation of security over the property charged and making the execution creditor a secure creditor, meaning that the property is what you use to secure the loan, who must enforce the security in order to realize the proceeds of the judgment or order. The charge affects only the beneficial interest of the execution creditor in the property and no more. The execution creditor gets no more than the execution debtor could have given. So if you look at page 1036, it provides as follows. A judgment creditor who for some reason cannot otherwise levy execution against the interest of a judgment debtor in a property may apply for a charging order which would have the effect of an equitable charge created by the judgment debtor. The judgment creditor may then realize the judgment debt by sale or appointment of a receiver. A stock standing in the name of a trustee in trust for the judgment debtor may be charged. This page has some critical information. It says that there is a judgment creditor, but there's some reason for which he cannot levy execution against the interest of a judgment debtor. He can apply for a charging order. The effect of the charging order will be that it will have the effect of creating an equitable charge over a property belonging to the judgment debtor. So how would a judgment creditor get his money? It says that the judgment creditor may then realize the judgment debt by sale or appointment of a receiver. So we are also told that a stock, even stocks standing in the name of a trustee in trust for the judgment debtor may also be charged. So that even if there are some stocks that somebody is holding in trust for you, the judgment debtor, we can create a charge over that stock so that we can sell it and easy to realize the judgment debts. So if you look at Order 49 Rule 1 of the High Court Civil Procedure Rules 2004 CI 47, it clearly provides for what a charging order is and how we can even apply for it. Remember, we are having a discussion on how you can enforce judgments to realize the proceeds of your judgment debts. Order 49 Rule 1 says that, and I quote, "The courts may, for the purpose of enforcing a judgment or order, for the payment of money to a person, by order, impose on any immovable property or interest in immovable property of the debtor a charge to secure the payment of any monies due or to become due under the judgment or order as may be specified in the order." So take a look at Order 49 Rule 1 again. It says that the court may, for the purpose of enforcing a judgment or order, for the payment of money to a person. It is telling you that we use charging orders to enforce judgments or orders for the payment of money. So if you have a judgment in your favor that somebody must pay money to you and hasn't paid, the Order 49 Rule 1 is saying that the court may, by order, impose on any immovable property or interest in immovable property of the debtor. The court will impose a charge that will secure the payment of any monies due or to become due under the judgment or order as may be specified in the order. So that's what a charging order is. If you are applying for it, Order 49 Rule 1 Sub Rule 2 says that an order under Sub Rule 1 shall be in the first instance to show cause. An order under Sub Rule 1 shall be in the first instance to show cause, specifying the time and place for further consideration of the matter, and imposing the charge until the time in any event. And Order 49 Rule 1 Sub Rule 3 says that an application for an order under Sub Rule 1 may be ex parte. Why would it be ex parte? You want to go and create a charge over somebody's property. That will be a security for you to enforce the judgment to recover the money. So if you want to create a charge, the law says that you can go to the court on an ex parte application alone, go and get the order, and the order will be served on the person. And then the person will now come before the court to explain to the court, show cause why we should not create a charge over this particular property. And if you can't show it, then the court will now create a charge over the property. And once the charge is created, it becomes a secured charge, and the judgment creditor will be placed in the position of a secured creditor so that he can realize his security as a way of getting back his money. But take a look at Order 49 Rule 1 Sub Rule 4. It says that there may be joined with an application for an order under Sub Rule 1 an application for the appointment of a receiver to enforce the charge imposed by the order. In other words, if I'm applying to the court for a charging order, I can accompany my application with the appointment of a receiver so that I'll pray the courts. Not only should you create a charge, but you should also appoint a receiver so that once the charge is created, the receiver will be the one that will realize the charge for me to get back my money. When you're applying for a charging order, what should be the components of the affidavit in support? You will see that under Order 49 Rule 5. Order 49 Rule 1 Sub Rule 5. It reads as follows, and I quote: the application shall be supported by an affidavit. A. Identifying the judgment or order to be enforced, and stating the name of the judgment debtor on whose immovable property or interest it is sought to impose a charge, and the amount remaining unpaid under the judgment or order at the time of the application. B. Specifying the immovable property on which or an interest in which it is sought to impose a charge. And C. Stating that to the best of the information or belief of the deponent, the immovable property or interest in question is the judgment debtors, and stating the sources of the deponent's information or the grounds for the deponent's belief. So, if you are applying to the court for a charging order, of course, you must tell the court the judgment you are seeking to enforce. Tell the court the name of the judgment debtor on whose immovable property you want to create a charge. You must also specify the property. Is it house number 5? Specify the property. And show us, to the best of your information or your belief, that this property is one that belongs to the judgment debtor. If you show these things, that is where we can create a charge. We want to be sure before we go and create a charge over someone's property when there's no need to do so. Order 49 Rule 1 Sub Rule 6. It says that unless the court otherwise directs, a copy of the order shall at least 7 days before the time appointed for further consideration of the matter be served on the judgment debtor, and if the judgment debtor does not attend, proof of service shall be given. What is happening over here? You remember we mentioned that when you bring the application, if you look at Order 49 Rule 1 Sub Rule 2, it says that an order under Sub Rule 1 shall in the first instance be an order to show cause, specifying the time and place for further consideration of the matter, and imposing the charge until the time in any event. Meaning that the first order that will be given will not be the one that will complete the whole creation of the charge. The first order shall be an order to show cause, so that the person who is claiming that the charge should be created, you apply to the court will grant the order. When the order is granted, it shall be served on the judgment debtor, and the effect will be that the judgment debtor should show cause why the charge should not be created. So the first order that will be served on you will state the time and place for further consideration. So you are serving on you this order. Appear and come and tell us, show cause why the charge should not be created. So what Order 49 Rule 1 Sub Rule 6 is saying is that this order to show cause, it shall be served on the judgment debtor, but there must be at least 7 days. If you serve the judgment debtor, at least there must be 7 days before the case will be heard. So if the order is granted today, and I come and serve the judgment debtor tomorrow, the date at which he's supposed to appear before the court, it must be served at least 7 days before you appear before the court. If I serve you tomorrow, at least 7 days must pass so that you appear before the court and come and show cause why the charge should not be created. That is why Order 49 Rule 1 Sub Rule 6 says that unless the court otherwise directs, a copy of the order shall, at least 7 days before the time appointed for further consideration of the matter, be served on the judgment debtor, and if the judgment debtor does not attend, proof of service shall be given. What if the person appears and then he's not able to show cause why the charge should not be created? Order 49 Rule 1 Sub Rule 7 says that on the further consideration of the matter, the court shall, unless it appears that there is cause to the contrary, make the order absolute with or without modifications. So once it is made absolute, it means that the charge has been created over the property, and therefore steps can be taken for the charge to be realized, so that the judgment creditor, can get the proceeds of the judgments. So that is the import of Order 46, Order 49 Rule 6. Look at Order 49 Rule 6, Sub-rule 3. It says that a charge imposed by an order under sub-rule 2 shall have the same effect, and the judgment creditor in whose favor it is made shall, subject to sub-rule 4, have the same remedies for enforcing it as if it were a valid charge effectively made by the judgment debtor. So what in essence is being said is that under Order 49 Rule 6 of the CI 47, Sub-Rule 3 says that a charge imposed by an order under Rule 2 shall have the same effect, and the judgment creditor in whose favor it is made shall, subject to Sub-Rule 4, have the same remedies for enforcing it as if it were a valid charge effectively made by the judgment debtor. It means that once the court orders the charge to be created, once the court orders the charge to be made absolute, the judgment creditor can enforce it as if it was a valid charge that had been created already by the judgment debtor. So the same way that any charge can be executed, the same way that we can execute it, so that we can help the judgment creditor get his money back. But in between the time of creation of the charge and for the time for it to be executed, there is a statement of the law about it. Look at Order 49, Rule 6, Sub-Rule 4. It says that no proceedings to enforce a charge imposed by an order made absolute under this rule shall be taken until after the expiration of 3 months from the date of the order being made absolute. Again, no proceedings to enforce a charge imposed by an order made absolute under this rule shall be taken until after the expiration of 3 months from the date of the order being made absolute. What does this mean? It means that when I apply to the courts, remember the first application will be an application for the judgment debtor to come and show cause. So that will be made ex parte. We apply to the court for an order, and the judgment debtor will be served to appear before the court to come and show cause why the charge should not be created. If he appears and is not able to show cause why the charge should not be created, the court will proceed to make the charge absolute. And remember, once the charge is made absolute, it will have the same effect as if the charge had been validly created by the judgment debtor himself. Now, when the charge is made absolute, what time do we have to even realize the charge or the security to get the money? The law says that you must leave 3 months. That's the import of Order 49 Rule 6 Sub-Rule 4. That no proceedings to enforce a charge imposed by an order made absolute under this rule shall be taken until after the expiration of 3 months from the date of the order being made absolute. So remember, we are all having this discussion because we want to identify this way of enforcing the judgment for the recovery of money. It's all about enforcing the judgment for the recovery of money. So once you owe me, you have not paid, I know your property, I can apply to the court and get a charging order that will create a charge over the property. So that once the charge is realized, then I can also get my money back. And remember, under Order 49 Rule 8, Sub-Rule A, how do you even realize the charge? The law says that the court may appoint a receiver to enforce a charge imposed under Rule 1. So, to realize the charge, I won't go and install it myself. The law says that a receiver may be appointed that will carry out with the realization of the security. What are the categories of properties that we can create a charge over? Is it only over land that we can create a charge over? Interestingly, Order 49 Rule 2 provides that it's not only land that we can create a charge over. When you go through Order 49 Rule 2, you realize that even shares that the judgment debtor has in the company, we can create a charge over those shares. So Order 49 Rule 2 is headed Order Imposing Charge on Securities. And it reads as follows, and I quote, "The order for the purpose of enforcing a judgment or order for the payment of an ascertained sum of money may by order impose a charge on any interest in securities to which the judgment debtor is beneficially entitled. Securities. Order 49 Rule 2, Sub Rule 2. Any securities to be charged under this rule shall be specified in the charging order. Rule 3. The securities to which this rule applies. The securities to which this rule applies are A. Government stock standing in the name of the Accountant General. B. Any stock standing in the name of the Accountant General. C. Any dividend or interest payable on stock mentioned in paragraphs A and B. The lawmaker goes ahead to explain what we mean by stock and under 49 Rule 4, Rule 2 Sub Rule 4, says that in this order, stock includes shares, debentures, and debenture stock. So we are being told under the 49 Rule 2 that the kind of properties that we can even impose a charge on is not only immovable property, it can also include securities, like shares that you have in the company. Remember, we had this entire discussion on charging order as a way of identifying how we can enforce a judgment for the recovery of money. It's your money you want. So the law says that to get your money back, you can go to the court on an ex parte application, get an order for a charge to be created over the immovable property of the judgment debtor or securities that the judgment debtor has. So once the charge is created over the immovable property or the securities, next thing that it has to be realized for you to get your money back. At this point, the question that many people will be asking is that how does the charging order then differ from a writ of fieri facias? So I'll wrap up the discussion on that one by referring to the statement I read from Kwame Tete's book at page 1036. I'm referring to the book authored by Kwame Tete titled Civil Procedure, a Practical Approach at page 1036. This is what it says. For some reason, it may not be convenient to levy execution against a property standing in the name of the judgment debtor or property in which the judgment debtor has interests. For example, the judgment debtor may only own the reversion. And now let me explain this. It could be that the judgment debtor has a land, he has given a lease to somebody for 5 years. But after the 5 years, it's coming back to the judgment debtor for the next 75 years. So it may not be convenient for you to go right now and go and sell the property because there's somebody already in the building that has a lease for 5 years. So what do? It says that, for example, the judgment debtor may only own the reversion. So in that case, the executing creditor can obtain an order charging the property with the judgment debt. So from this statement, it means that there may be times when it may not be convenient to go with a fieri facias for an outright sale. In that instance, you can create a charge. The charge will serve as a security that you can take steps at a time that you want to realize the charge to get your money. And that is what you mean by charging order. So you can read Kwame Tete's book for more information about it. By this point, what we know is that charging order is one of the modes we can use to enforce judgments for the payment of money. And the charge need not be created over only immovable property. It can also be created on securities, as we've seen under 49 Rule 2 of the CI 47. And the securities include shares that the judgment debtor has. We can create charges over all those properties. Now the next thing, if you notice, we mentioned that even when you are creating a charge over a property, we mentioned that a receiver can be appointed that would help you realize that particular charge. We mentioned the receiver. But the reason we must discuss a receiver is because if you look at Order 43 Rule 1, when it was giving us the different modes of enforcing judgments for the recovery of money, look at the D. It says that we can enforce the judgment for the recovery of money by the appointment of a receiver. So appointing a receiver is a different mode of enforcing judgments for the payment of money. So we need to understand who a receiver is, because it's one of the modes that you've been afforded under the rules to enforce the judgment for the recovery of money. So who is a receiver? There's a statement in this case of In re Manchester and Milford Railway. In re Manchester and Milford. Milford is spelled M-I-L-F-O-R-D. Railway Company. Ex parte. Cambrian. Cambrian is spelled C-A-M for mango. B-R-I-A-M for mango. Ex parte Cambrian Railway Company. Reported as far back as in the year 1880. 14th Chancery Division at page 645. This is how Jessel M.R. defined a receiver. Says a receiver is a term which was well known in the Court of Chancery as meaning a person who receives rents or other income paying ascertained outgoings, but does not, if I may say so, manage the property in the sense of buying or selling anything of that kind. End of quotes. A receiver is a term which was well known in the Court of Chancery as meaning a person who receives rents or other income, paying ascertained outgoings, but does not, if I may say so, manage the property in the sense of buying or selling anything of that kind. Again, a receiver is a term which was well known in the Court of Chancery as meaning a person who receives rents or other income. So you receive rent or other income, you pay ascertained outgoings, but does not, if I may say so, manage the property in the sense of buying or selling anything of that kind. Have this definition at the back of your mind while we interrogate how the CI 47 makes provision for receivers. I believe you've already taken note of Order 43, Rule 1D. Because under the CI 47, there are several instances under which a receiver may be appointed. So we are going to look at the instances in the CI 47 under which a receiver may be appointed. I believe you know one already. Because when we dealt with charging orders, remember that under charging orders, we mentioned that a receiver may be appointed to help the realization of the charge that will be created. So before I begin, remember that one circumstance under which a receiver may be appointed is under 49 Rule 8 of CI 47, which is for the purpose of enforcing a charge order made by the courts. So under the 49 Rule 8 of the CI 47, for the enforcement of a charging order made by the courts, a receiver may be appointed. That's one of the circumstances. Another circumstance that we shall look at is that a receiver may also be appointed for the enforcement of an order for the payment of money into court. And also, a receiver may be appointed for the enforcement of a judgment for the payment of money to a judgment creditor. So we shall look at three circumstances under which a receiver may be appointed under the CI 47. A receiver can be appointed, one, to enforce a charging order made by the courts, or a receiver can be appointed to enforce an order for the payment of money into court. And also, a receiver may be appointed for the enforcement of a judgment for the payment of money to a judgment creditor. So I shall take each of these ones and deal with them one after the other. Starting point is to look at Order 43, Rule 1, Sub Rule D. Order 43, Rule 1, Sub Rule D. It reads as follows. Subject to these rules, a judgment or order for the payment of money, not being, emphasis, not being a judgment or order for the payment of money into court. Not being a judgment or order for the payment of money into court. It may be enforced by one or more of the following means. Then it mentions the appointment of a receiver. So under this Order 43 Rule 1D, it is dealing with payment of money to a judgment creditor, which is not payment of a money into court. It may be appointed by it may be enforced by the appointment of a receiver. That's one of the instances. That's why I mentioned initially that there are three ways we will look at. One way is when we are looking at the enforcement of a judgment for the payment of money to a judgment creditor. That's one way we can use a receiver. That's why it reads that subject to these rules, a judgment or order for the payment of money, which is not a judgment or order for the payment of money into court, it may be enforced by appointment of a receiver. Then Order 43 Rule 2. That one deals with enforcing a judgment for the payment of money into court. Order 43 Rule 2 says that subject to these rules, a judgment or order for the payment. And so we are referring to Order 43 Rule 1, Sub Rule 2. It says that subject to these rules, a judgment or order for the payment of money into court may be enforced by one or more of the following means. A, the appointment of a receiver. So the appointment of a receiver is another way of enforcing a judgment for the payment of money. And then this time around, it is in relation to enforce a judgment for the payment of money into court. So we've seen two ways so far. One way we saw was on Under 43 Rule 1D. That is enforcing a judgment for the payment of money to a judgment creditor, which is not payment into court. You can appoint a receiver. Second instance, enforcing a judgment for the payment of money into court. You can also appoint a receiver. What is the third circumstance under which you can appoint a receiver? We dealt with it already. That is for the purpose of enforcing a charge created pursuant to a charging order. Look at Order 49, Rule 1, Sub Rule 1 of CL 47. It reads as follows. The court may, for the purpose of enforcing a judgment or order for the payment of money to a person, by order, impose on any immovable property or interest in immovable property of the debtor a charge to secure the payment of any monies due or to become due under the judgment or order as may be specified in the order. Then the most critical part is Order 49 Rule 1 Sub Rule 4, that there may be joined with an application for an order under Sub Rule 1. That is, when you're applying for an order, for a charging order to be created, an application can be added for the appointment of a receiver to enforce a charge imposed by the order. So Order 49 Rule 1 Sub Rule 4 says that there may be joined with an application for an order under Sub Rule 1, an application for the appointment of a receiver to enforce the charge imposed by the order. And then finally, to make it clear, Order 49 Rule 8 says that the court may appoint a receiver to enforce a charge imposed by an order under Rule 1. So you've seen three ways and circumstances under which a receiver may be appointed. And what is common about all these three circumstances are that they are all for the purpose of helping us recover some money. Circumstance number 1, enforcing the judgment for the payment of money to a judgment creditor, which is not a payment of money into court. You can appoint a receiver. Again, for the purpose of enforcing a judgment for the payment of money into court, you can appoint a receiver. Then finally, to realize a charge created over a property pursuant to a charging order being made by the court, you can also appoint a receiver. This brings us to the end of our lecture on charging orders and appointment of a receiver as two different modes of enforcing judgments for the recovery of money. We've dealt with charging orders, and we've dealt with appointment of a receiver, and we've dealt with the three different instances under which a receiver may be appointed. Remember charging order. We said that you shall create a charge over the property, and it can even include securities, and it will be realized for you to get your money. Remember, appointment of a receiver, three circumstances: paying money into court, paying money to a judgment creditor, or enforcing a charge. created pursuant to a charging order. In our next lecture, we shall deal with executing judgments by committal and sequestration. This is where we shall draw the curtains for this lecture. Thank you.